says you only get involved when your attorney, Mr. Jodecki, indicates it's appropriate for you to get involved. Otherwise, silence is golden.
Okay, got it.
All right, that's the sign that the Zoom feed is live now. Next, I have Mr. Jodecki. How are you doing, sir?
Good, Your Honor. Good morning.
You represent Mr. Myers as well as ACM3, is that correct?
That's correct, Your Honor.
Does anyone else on this call also represent plaintiffs?
Yes.
Who's that?
Good morning, Your Honor. Mr. Caskey.
Okay.
Mr. Caskey is an associate in my office and we're actually sitting in the same office, 6 feet apart, of course.
Okay. Well, great. Thank you both for joining. I see Ms. Tuttle on the phone. Ms. Tuttle, who do you represent in this case?
All right. Yes, Your Honor. Hi, I represent RPL in this case, along with Mr. Allen, and we are not directly involved in today's summary judgment, as you stated, but are interested parties, and so are here to see how it all turns out.
And RPL, if I'm remembering correctly, is a party that has subsequently acquired one or more of the parcels that supposedly secured the loans that Mr. Myers gave to Summit and Crown. Is that correct?
That is correct, Your Honor. We're on one of the properties. RPL is the purchaser at the end of the line that currently holds title to the property. Just on one of the properties, there's a number of properties that are involved in this case. We are just on one of them.
Which one?
Oh, well, then now as you sit there and say that, I completely am blanking on the name of the address.
Holiday, Ormwood, Beacon Hills, Portland.
It's the Ormwood property, Your Honor. Sorry about that.
No problem. All right, Ormwood it is. Mr. Johnson, good morning. You represent Mr. Golhar as well as, is it Blue Summit, or do you represent Summit and Crown? Remind me.
Summit and Crown.
Okay, and Mr. Golhar.
Yes, sir. And Mr. Golhar is here with me.
Hello, Mr. Golhar.
Good morning.
All right, so SNC and Golhar is Mr. Johnson. Does anyone represent Blue Summit anymore? Did they ever have counsel?
I think at some point they had counsel. I don't think I ever filed a notice of appearance for them. They're really kind of a non-entity at this point. I don't think it's germane to anything we're doing today. Well,
and the name may come up. As I was looking at some of the notes, it looked like Blue Summit signed, and that was Mr. Golhar's LLC, if I'm...
That's correct.
Okay. And am I also correct, Mr. Johnson, that your response to the partial motion for summary judgment was on behalf of Mr. Golhar only?
That is correct. And so perhaps we can shorten today's proceedings. Summit and Crown has no defense to the promissory note claims. And so judgment should be taken against that company.
Okay. I expected to hear as much, and I think that does truncate things a little bit, but we'll get more official in a minute. Just want to make sure I understand who all is here. Mr. Caskey is with Mr. Jodecki. Ms. Foster is our court reporter. Hello, Ms. Gilroy.
Hello, Your Honor. How are you?
I'm well. Who do you represent?
Always good to see you. I represent Resolutions team, a defendant. We actually we bought from Summit and Crown, and we sold to Mr. Barton's clients prior to this lawsuit being filed. But we also, and we're only involved in the Holiday property, but we also are just here with an interest in the outcome.
Okay. Mr. Barton, good morning.
Good morning, Your Honor. I represent the most recently intervening defendants who are the current owners of the Holiday property, which is now 2 units. So it's Mr. Dandria, Ms. Russert, Ms. Shue, and Mr. Luzier. And we are just observing today.
Are they owner occupants or owner investors?
Owner occupants.
So they have a pretty clear interest in what happens with all this.
Indeed, they do.
It's called the roof over their heads. All right, well,
That's
thank you
correct.
for being here.
Thank you.
Ms. Niles is my staff attorney, and Mr. Allen is with you, Ms. Tuttle. Am I remembering correctly? Okay. Okay.
Jefferson Allen, Your Honor, I also represent RPL. We're different firms, but I represent RPL.
Okay, great. And then there's a phone number, a 678 phone number. Who's on that line?
That might be the court reporter.
The court reporter, sir.
Oh, great. Okay, just need to make sure that like my mom hasn't dialed in and I have to behave differently if she is on this call. She actually every once in a while will watch on YouTube. She says it helps her sleep, which I don't appreciate, but my brother is a sports reporter. His YouTube feed is much more interesting than my YouTube feed. All right. Well, let's get started. Mr. Jodecki, my read of your motion for summary judgment, which is about 14 pages of statement of facts and about 2 paragraphs of law, is look, there was default. These notes matured, no payments were made. I don't think no is quite right. I think there was some small amount that Mr. Myers has received, but nothing close to what he's owed. And Mr. Johnson's acknowledged as much, and Summit and Crown is liable. And so the way I read the response from Mr. Johnson is that, so I cover it all. Mr. Higgins has never answered. I don't know if he's just in the wind, if you have any idea where he is, but either way, he's in default. He was in default through the process of not answering. But where Mr. Johnson has engaged is to make the argument that Mr. Golhar is not individually liable because he didn't personally guarantee any of these loans. We should talk about that today because you may point to, on some of the loans I noticed or notes, there is a signature from Mr. Golhar and it says individually. It's not on all of them. And Mr. Johnson's made the argument buttressed in part by Mr. Golhar's affidavit saying, I didn't mean to individually guarantee anything. I never had a conversation with Mr. Myers about my personal net worth or ability to guarantee things. This was always a Myers and ACM3 S&C transaction. And then, by the way, legally, it's a question of fact whether Mr. Golhar meant to or intended to personally guarantee any of those loans. I think that's the narrow issue we talk about today, but you're the movant, and I'm happy to talk about what you think we ought to do with, I'll call it S&C for short. That seems to be what people are doing. What you think we ought to do with Higgins. But my understanding is that you're focused on those 3, Higgins, S&C, both of which seem like they're pretty simple answers. And then Golhar, where maybe that's something that gets punted to trial because it's the final fact finder who needs to determine what was Golhar's intent, what was Myers' reasonable reliance on signatures that say signed individually as opposed to member of Blue Summit or S&C. That's my framing of it. I don't mean to suggest it's in any way accurate. That's just, as Ms. Niles and I have been talking about the case to prepare for today, that's sort of where I came down. But I leave it to you to take it from there.
Thank you, Your Honor. Can everybody, can you hear me?
Yes.
Okay. Just never know these days. I think your framing of it, at least as I understand Mr. Johnson's response, and he can speak to that, but that I think is right. With respect to the summary judgment motion, and I'm not going to go deeply into the facts because you have those, and it sounds like you've reviewed those pretty significantly. But what we're looking for is a judgment jointly and severally in the amount of $282,972 against defendants Summit and Crown, Higgins, and Golhar. And that's related to three promissory notes: the Holiday Avenue note, the Ormwood note, and the Windle Down note. And
Where is Win? I'm going to interrupt you for a second.
Sure.
Where is Windle Down now? That seems to be a property where we don't have additional defendants saying, well, wait a minute, I own that now. Mr. Myers doesn't have a claim to that property.
Sure. And I don't have my property chart in front of me, but what I can tell you is that generally there were two of these properties where we had security interests in them that, but for what we believe are forged deeds, we believe would survive. With respect to Windle Down, I think there may have been a senior lender in front of us who may have foreclosed that property, or we don't think we have a direct interest in that property. And that was, you know, why we are where we are. We don't have a forgery or anything like that. We think that property, you know, got away from us as a lender.
Okay.
So that's why you don't see other defendants on that one.
Okay.
So Holiday, Ormwood, and Windle Down, the facts will show that those three were signed by Summit and Crown. You have Walt Higgins individually, and then Abby Golhar as Blue Summit, and then we contend Golhar and Higgins also signed individually as makers. So that's three of the notes. The fourth note is a little different, and in addition to the judgment jointly and severally that I just told you, we're also seeking $111,270.61 solely against Summit and Crown. And what ends up happening there is a fourth note. We had a fourth note, which was a Beacon Hills Boulevard note, which was originally in the amount of $150,000. And what ends up happening is there is one payment that gets made to my client, and that's roughly $61,000. And what ends up happening with that that Beacon Hills note is he gets a partial payment in connection with the closing, and then gets a new promissory note. And that promissory note is different than the other notes in that we don't have a situation where Higgins and Golhar appear to sign that individually. That's strictly a note that references Summit and Crown. So,
and then he gets the Portland Avenue note in exchange.
Yes.
Okay.
So,
and that's where the 111,000 is.
Right. And I've got a chart that's going to show all this. And we've attached a chart to our motion as Exhibit N that kind of runs you through the whole thing. But I wanted you to understand that we've got three notes: Holiday, Abbott, Ormwood, and Windle Down, which we contend all of them are responsible on, all of the Golhar parties. And then on the one Portland Avenue note, which is a substitute note, that one is solely Summit and Crown.
Okay. So let's talk a little bit. You've helped me look at it on one dimension, which is properties and notes. Let's now look at it on the dimension of defendants. Higgins is in default. He did not answer. You don't get summary judgment by default, no such thing. But he's deemed to have admitted all the material allegations in the complaint. Is there anything that you allege that he's deemed to have admitted that would make him personally liable? And I'm distinguishing that from Summit and Crown. Mr. Johnson's waved the white flag for Summit and Crown. But how is Higgins, other than the signatures that we see on some of the notes, how is he personally liable for any of the 282,000?
Well, he has signed the notes in an individual capacity. He signs what ends up happening with Summit and Crown, and we've got other claims against Higgins that are not in this summary judgment motion, but with respect to just the notes, you have Summit and Crown, which is made up of members Walt Higgins and Blue Summit LLC. And then when you look at these notes, Walt Higgins II has also signed as a maker of the note. individually. And why don't, can you pull up the signature page of the holiday note?
So I've looked at the notes, and what I did not see, which is what one typically, I say typically, I don't deal a lot with secured lending and things like that. But what I have often seen is language in the note that says, oh, and by the way, Higgins and Golhar individually guarantee. I didn't see the word guarantee anywhere in the note. In fact, the only time the word individually appears in the note is on the signature line. I'm not saying that the absence of the word guarantee or the word individually anywhere other than the signature line is, there's that cup again, is fatal to your argument, but doesn't it leave it then to Mr. Myers believes one thing, Mr. Golhar believes another thing, and a fact finder needs to work through whom to believe?
I don't believe so, Your Honor. And I've got some cases here that I'll talk about, including that case I cited in the brief.
Okay.
We're not contending, first of all, that there's a difference here. Golhar, we're not saying he's a guarantor of some kind. Higgins is a guarantor of some kind. You've got makers, you can have endorsers, you can have accommodation parties, you can have you can have guarantors, you can have sureties. There's all different aspects of that. And with respect to this specific promissory note, it does list the maker as Summit and Crown. If you then look into the body of the note, it talks about how there can be other makers and that they'd be jointly and severally liable. And then when you go to the end, they've signed the note twice. They've signed once as a party to Summit and Crown Partners, and then they signed once individually. If you look at the Carol Stouffer case, let me walk through some of these cases, and I'll do it to answer your question about the intent. I think intent in these situations is not relevant, and that this is somewhat of a red herring argument. And the reason for that is a couple things. One, as I understand the argument, it is we signed it superfluously, or we signed as maybe some type of accommodation party. We could find no case in Georgia law that said when you had two signatures, that one of them is superfluous and you should give it no meaning whatsoever. If you look at the Carroll versus Stauffer case, that's the one we cited.
Yeah.
And let me tell you, Judge, just right at the beginning, when we cited the case in the brief, we did not mention that the case has been limited, but when I prepared for the hearing, I noticed that the case has been distinguished on other grounds. So I just want to make you aware of that. We didn't say it in the brief. I apologize for that, but I noticed that at the hearing. But in the Carroll versus Stouffer case, what you had was you had a note that was signed twice. The first time it's signed by Dental Corp of America, by the guy as president, and then underneath it, it's signed again by the guy, and it doesn't give any kind of distinction. And the fellow who signed it was this guy named Carroll, and Carroll makes virtually the same argument that's made here. He says that the parties did not intend that Carroll obligate himself individually, and the court rejected that. I mean, they went and said, you know, it's self-evident that appellant would not have signed the note twice if the only debtor was the Dental Corp of America. It is plain beyond dispute that appellant would not have signed the note again in the space above the words William E. Carroll Jr., which were identical in form to the typed Dental Corp of America, unless he intended to obligate himself equally in stature and form to Dental. So we're not saying he's a guarantor. We're not saying anything about surety. We're saying he's a maker. Golhar obligated himself, and even more so. Can you see it on the four corners of the note? Than in the fact it says individually next to his name. You don't have that in the Stouffer case. I think our case is more compelling than that Stouffer case.
Okay, I'm looking at the holiday note now, and if we go to the last page, they're not numbered, so it's just the last page of the holiday note. It does say in all caps maker : and then there are effectively three makers. One way to read it would be there are three makers, Summit and Crown, and then it's signed by Summit and Crown's members, which is Mr. Higgins and Blue Summit. And then there are two more signatures, Walt Higgins individually, who's already signed once as member of Summit and Crown. Right. And then Mr. Golhar is signing again, who had already signed once as effectively Blue Summit. So I'm understanding your point now. Where in the note does it say there can be more than one maker, they're jointly, severally liable, whatever language you use?
Alex is going to share his screen. We're going to put that up, but it's on page 2. It's the third paragraph from the bottom, and it's the last sentence of that third paragraph from the bottom. And it says, in the event that more than one person, firm, or entity is a maker hereunder, then all references to maker shall be deemed to refer equally to each of said persons, firms, or entities, all of whom shall be jointly and severally liable.
And the notes for a couple of properties seemed pretty much identical other than the name of the property. So I assume there's a paragraph just like this in Ormwood.
Yeah, in the Ormwood and the Winnell Down, they have a virtually identical language. This paragraph is in both of those.
Okay.
And Alex has put up on the share screen, hopefully y'all can see it, but that's the portion of the note we were referring to.
Yeah. Okay.
Judge, we cited, I think, one case in the brief, and we started to do a response brief, but then realized since we were having this hearing, and I know you have some specific rules, we did not file that. But I have a couple other cases that also back up this proposition. Vick versus Mercer, 194 Georgia App 785. It's a Court of Appeals case. Cert was denied in 1990. It's also a suit on a note. And this case supports us as well. And let me just make sure I've got my facts here. Was this a two signing note? Do you remember? Yeah. Yes. This was a note as well. Yeah, and this is a reversal, actually. A trial court in this case actually found that there were issues of fact relating to the understanding of the parties. The Court of Appeals then came along and reversed them. The trial court had relied on a case, a Kramer case, and the question in that case was different. The court said that, well, there we were looking at whether the note, because it lacked the name of the company, whether that could make the signer personally liable. In our case, we had 3 debtors, corporation and 2 of its officers, and they had 3 distinct signatures. And like Golhar, defendant officers raised a factual issue by arguing they subjectively misunderstood the capacity in which they were signing. The court, in reversing the trial court's denial, rejected this argument, held no issue of fact existed because the face of the note unequivocally shows that the individual defendants did not sign in their representative capacities. Same as here. You look to the note first before you start to get into what parties' intent are, parole evidence. The note itself says that these guys are makers. Golhar, Higgins, as well as Summit Crown. In addition to Vick, another case that comes up.
So let me pause you for a second on that, just to play devil's advocate. If we look at the note, the very first sentence, this is the Holiday Avenue one. For value received, the undersigned, Summit and Crown Partners, LLC, hereinafter referred to as maker. It doesn't say comma Higgins, comma Golhar. So it does seem like this is not the clearest commercial promissory note that's ever been written, because we're introduced to the parties Our maker is SNC. Our holder is ACM3. That there's no mention of Golhar or Higgins anywhere in the document until we get down to the signature block, which then does appear to say, although it doesn't say makers, it says maker, and it does have their signature. So I'm hearing you on this, but I don't know that it's unequivocal from the note, given how it starts. That might have been another good place to list Mr. Golhar and Mr. Higgins as makers.
It could have been, Your Honor, but I will say that didn't necessarily happen in these cases either. And it's once you put that double signature on there, the only way you can ignore that is to treat it as nothing, and that's not how we do things in Georgia. And you know, hindsight being 2020, I'm sure they would have put those names on it. I know I saw in the affidavit, hindsight being 2020, Mr. Golhar said he wouldn't sign it because they would have come after him. And I'm sure hindsight being 2020, my client wishes he wasn't involved in this either. But you know, that's where we find ourselves. And you know, I would point this out too, and I can go through the other side's cases as well. But what you have here is whether or not, at most, what you would call this party is an accommodation party, an accommodation party who signed as a maker. And when you're an accommodation party, it's not going to matter when it comes to the lender in this case. You may have certain rights against your other makers. You know, you may not be primarily liable as an accommodation party. You may be secondarily liable, or you may be able to sue the original party, Summit and Crown, for the entire amount, as opposed to, you know, some limited amount. But even the cases that are cited by opposing counsel, and I can go through those, they essentially, Darien versus Miller and Barilak versus Jordan. And Darien versus Miller, when you read that case, and that's one that's cited in the opposition brief, first of all, it's a collateral impairment case. We didn't have that issue here. It did involve a lender. I think the lender had a shrimp boat that he ended up taking possession of that ended up catching fire or something to that effect. One of the key points in that case, and I'm flipping around here, but I have them here on my desk. One of the key points in that case, it says, although as an accommodation party, Miller would remain liable to the bank in his capacity as co-maker. So it doesn't become an issue for us. He signed as a maker. I mean, that's, you know, even if you want to say what Mr. Johnson is left with is either he signed it superfluously and it has no meaning under law, or he signed it as an accommodation party. Now, I'll tell you, there is no evidence in the record that he signed as an accommodation party. Even Mr. Golhar's own affidavit simply says, well, if I knew that I was going to be personally liable, I wouldn't have signed it at all. But there's no evidence in the case that he signed it as an accommodation party. The only evidence in the case is the four corners of the note where he signs it as a maker. And even if you said he was an accommodation party in the case, he's still a maker because that's how he signed it. And the cases that are cited by me and the cases that are cited by Mr. Johnson make it clear that even if you're an accommodation party, you could be a maker as that accommodation party. So the obligations that you end up having, the Darien Bank versus Miller case goes on to talk about, you know, what rights does the accommodation party have if he is an accommodation party as opposed to a maker. He retains a right of recourse against his co-maker, potentially for the entire amount, as opposed to if you're jointly and severally liable, you may only get a portion of whatever your debt is. And then this case goes on to talk about some rights that he would have under 11.3.6061B related to destruction of collateral. 11.3.6061B is not even part of our code anymore. That has gone away. And I think what the court, what 11.3, I've spent some time looking at this now, but what they were doing was saying that if you were an accommodation party who was not a maker, you could have been an endorser or something else. Then if the bank did something bad with the collateral on their watch, you might have certain rights that others don't. I think since that provision is not in the statute anymore, the Georgia statute. But I think since that, you'll see that in Georgia law, we have provisions that if a lender, takes a piece of collateral and wastes it, the original maker has defenses, the guarantor has defenses, and I'm sure the accommodation party has those same defenses. I suspect that it's been expanded, and that's why you don't see that language anymore. But for purposes of the lender, I think at the end of the day, whether he's an accommodation party or he's simply a maker, he's a maker, whether he's a maker or an accommodation party, I guess is what I would say. And I would say on the cases that are cited, they're either all cases that involve a destruction of collateral, which we don't have in this case, a waste of collateral, or they're cases where the intent of the parties becomes relevant, like in Barilak versus Jordan. That's one of the cases he cites too. I think there's 3 primary ones. In Barilak versus Jordan, what you have is a fight between 2 defendants under the note. There's no lender issue in that case. You've got the appellant gives a promissory note to the bank. The bank claims that the appellee was a guarantor and he had to pay, which he does. And then the bank assigns the note to the one party, and that party that paid then demands payment from the other party. The other party then claims, well, wait a second, all I was ever was an accommodating party, and you fraudulently induced me into entering into that document. So intent becomes relevant because there's a fraud claim there, and there's no lender involved in that case. The lender got out at that point. So, and that case also was a trial. It went to a jury verdict. And then there was, they filed for error based on the denial of a directed verdict motion. I've got these up on my board here, and I'm trying to read my writing. But essentially, you had two people that were obligated under the loan suing each other, and one was claiming fraud. And the intents of the parties in that case, I would represent to the court, it's not on all fours with ours. We don't have a lender in that case. And if you read each of the cases they cite, you'll see that. I think the Darien versus Miller case is the one case maybe they cited with a lender. And it's important to note that they say that whether he was an accommodating party or he was a maker, he's still a maker, and he's liable to the bank. And that's the most important thing here. I probably made this more confusing than it was when we started, but
you mentioned, Mr. Jodecki, that you had I think you said a couple other cases beyond the case cited in your brief because you decided not to seek permission to file a response or a reply. Do you have any others? You gave me the 194 Georgia Appeal 785. It made it sound like it was plural, not singular.
Yeah, it was. I appreciate you mentioning that to me. In my haste, I missed Adcock versus First National Bank of Atlanta is 144 Georgia App 394.
Okay.
And in this case, contention that the defendant signed only as an accommodation party for a third signatory was not a defense, since whatever their intention was, they were primarily liable as they signed in the capacity as makers. So this case talks about, well, even if you are an accommodation party, you signed as a maker, so you're primarily liable to the lender. So, I would submit this idea of accommodation parties. At the end of the day, you've got 3 notes that are very clearly signed, both the Summit and Crown and in individual capacities. And I did not see a single case, and I'm not aware of a single case where you have 2 signatures like that in this context where we choose to ignore one of them. And then even if you were to find somehow that Golhar is simply an accommodation party, again, there's no evidence in the record of that, which is different from the other cases that were cited. in that case, it's not going to make a difference when it comes to your liability to the lender.
All right, let me hear from Mr. Johnson about accommodation parties and signatures and whatnot. But before you dive into your defense of Mr. Golhar, since we are more officially on the record now, Mr. Johnson, you're acknowledging that Summit and Crown are liable for the 282 plus change for Holiday, Ormwood, and Winnell Down, and then the 111 plus change for Beacon Hills / Portland. Those are all loans that Summit and Crown obtained from ACM3, and they're in default. There was a slight payment on the Beacon Hills piece, but everything else is in default, and Summit and Crown is liable for those amounts. Is that a fair statement? I don't want to overstate it, but if we don't need to say much more about Summit and Crown, we can focus on the gentleman sitting next to you.
Sure. I can't speak to the precise amount that's owed under each note, but I agree generally with you that Summit and Crown is in default of the notes, has no legal defense. And so whatever the evidence is as to the amounts currently owing, that's what's owing.
Got it. Okay.
So I agree with Mr. Jardecki about one thing. There is no evidence in the record that Mr. Golhar is an accommodation party. And that's the entire point of our motion. You are either a maker or you are an accommodation party. And if you're neither one of those, then it's a superfluous signature. And that's what we have here. If anything, we have a triable issue as to whether Mr. Golhar is an accommodation party. I want to make one big point before I go into the nuances. If Mr. Jardecki's position were correct, that by mere virtue of you signing a note, you are a maker and therefore primarily liable to the bank, then there would be no body of law about accommodation parties, and there would be no statute about accommodation parties, and there would be no cases, because if you sign the note, if your signature is on a piece of paper with no identification of who you are, you're still primarily liable. That seems to be the argument. I think, and that's wrong.
Why don't you define for me accommodation party? What do you say accommodation party means?
It's a person who is not receiving the loan, is not benefiting from the borrowed money, but it's someone who is signing in order to make the deal go through, in order to give the other side some security that somebody else is on the note, that somebody else is going to take care of the note if the primary borrower is not taking care of the note. I think that's the statutory definition.
Okay, and I obviously go with the statutory one. It's a new term for me. How is it that Mr. Golhar did not benefit from these transactions going through?
He did not receive the money. And there's cases, and I think I've cited one in my brief, and if I haven't, I'll get to the case, but there's a case right on point that says, for the purposes of determining whether you're an accommodation party, the fact that you have an interest in a company that received the money does not mean that you personally benefited from the money. So there's a corporate distinction here, because Summit and Crown got the money. Mr. Golhar did not get it, and both sides agree on that point. Mr. Golhar did not personally obtain the money. Under the law about accommodation parties, he did not receive the value of the loan. He did receive the benefits of that loan.
So if the notes had as the signature block maker Summit and Crown Partners, and then Higgins and Golhar sign as members of Summit and Crown effectively, and then there was another block that said endorsed by or witnessed by or something like that, those folks who were endorsing, whatever that might mean, those folks who were witnessing, it's clear to me what that means. You're not liable for anything. You're just saying, I was here and I saw Walt Higgins sign it. Those folks would be accommodating parties, yes?
Depends on the facts. Remember, whether one is an accommodation party is a question of fact, and we'll get into the cases, but even the comment to the statute says that. And
okay.
The fact question is what the parties intended. So it's as if, let me give an example. I'm going to borrow money.
I'll let you do that. I will let you get into that, but there doesn't seem to be a whole lot of question if it says witnessed by. and it's got your signature there. I don't know how someone's going to say that you are responsible for paying any of that note. You might be in trouble if you didn't really witness it, but you let someone sign your name or something. But that strikes me as an example of an accommodation party. Do you agree?
If it says witnessed by, well, I think no matter what nomenclature is describing the capacity in which they're signing it, other than maker or personal guarantor, then there's a question as to whether they signed it as an accommodation party.
Okay.
I think witnessed is a weak example because that would seem to indicate that the parties intended that person just to sign as a witness to somebody else's signature. But I can see theoretically where someone could make an issue of it by saying, well, not only did I want him to sign as a witness, but I understood that he was going to make good if the borrower, the original maker, could not.
Okay. What is the question of fact about these notes? If you look at the signature block, what part of that makes one wonder, other than the parole evidence of, I don't mean this in a pejorative sense, but the self-serving affidavit of Mr. Golhar saying, whoa, even though I signed under the line that says maker, when I signed separately a second time individually, I didn't really mean to make myself liable. Apart from that parole evidence and the self-serving affidavit, what is there making this in any way a question of fact?
Two issues. One is just what's on the note. The fact that Mr. Golhar, as you've seen, is not identified as the maker. He is not the one with the primary responsibility for repaying this loan. The note itself identifies one party as the maker, Summit and Crown. And I can go through it with you. You know, there was kind of a red herring discussed a minute ago. The note itself, let me show you. The note itself, can you see the note?
Yes.
So this is the Beacon Hills note. They all have the same verbiage. It identifies Summit and Crown as the maker, and it's got this parenthetical hereinafter, whether one or more referred to as maker, but that's referring to whether this first sentence specifically identifies more than one maker.
Right.
And then if you go down to page 2, the sentence they were referring to, in the event that more than one person, firm, or entity is a maker hereunder, well, that just refers back to the beginning. Who is identified as the maker of this note? So I don't think that their argument that Mr. Golhar is a maker, even though he's not identified as a maker because the document contemplates more than one maker, I don't think that's a fair argument given the text of the actual note. And so the second point is, if he is not a maker, what is he? He's not a guarantor because there's no language of guarantors. The only other thing he can be is an accommodation party. And the question there is whether the parties intended for him to be an accommodation party and whether they intended that he be liable for the note. And aside from Mr. Golhar's affidavit, what you have from Mr. Meyer's own testimony is that, number one, there was never any discussion about Mr. Golhar's note name being on the note at all. Mr. Myers testified. Mr. Golhar presented the terms of the note. And let me show you one thing. I'll make this a little straightforward. Let me. Sorry, I'll get this to you in one sec. Can you see this?
Yes.
All right, so the parties never discussed Mr. Golhar having any personal role in this note. Both parties agreed. Mr. Myers admits in his deposition he never negotiated any of the terms of this note. Mr. Golhar told him what would be in the notes, and what the terms of the deal would be, and Mr. Myers accepted those. And I asked him specifically, what were the terms? And he said the terms were the amounts that he would loan to Summit and Crown, the loan fee that his company would receive in return for the loans, the time frame in which the loans would be repaid, and then on one note, the Beacon Hills note, there was an extra profit participation portion in the note. Those were the terms. And I specifically asked him, any other terms, hint, hint, did Mr. Golhar tell you that he would be personally liable or he would sign as an accommodation party? And the answer was not that I recall. Then Mr. Myers testifies about how these notes came to be. And he testified that his attorney, Mr. Campbell, prepared them, but he can't recall having any conversations about what Mr. Campbell was told to put in the notes. So Mr. Golhar didn't say, put my name and my signature on the note. Mr. Myers can't remember if he did or not. He doesn't remember what he told his attorney. So, and then one other point that I think is germane, Mr. Myers, if he intended that Mr. Golhar have any personal responsibility on the note, presumably you'd look to see if he had the financial ability to repay the note if Summit and Crown didn't. And he admits that he didn't do any of that sort of research. So what you have is the parties never discussed whether Mr. Golhar would be an accommodation party, never discussed having his signature on the note at all, never discussed what liability, if any, he would have if Summit and Crown couldn't pay the note. You have evidence from Mr. Myers' testimony that he never told his attorney what to put in the note, but ultimately there was a note with a signature block for Mr. Golhar, and he signed it, not as a maker. He just signed it with the word individually.
So am I following these deposition excerpts correctly in understanding that all the notes we're talking about were actually drafted by Mr. Myers' attorney and not by Summit and Crown's attorney?
Correct.
And I don't mean Mr. Jadecki, it's Mr. Campbell, whoever that guy is.
Correct. And there might be some confusion because originally in his affidavit, Mr. Myers said that he was completely unrepresented and yada, yada. Now
but he's cleared that up. I saw the supplemental affidavit and he remembers now that a lawyer helped him, but helped actually means wrote the notes that everyone signed. The author of the notes is Mr. Myers' lawyer, not Mr. Jadecki, but Mr. Campbell.
Correct.
Okay.
And so presumably, if you're going to get to the question of intent, Mr. Meyer can't remember what he told his attorney. Mr. Golhar says he never agreed to be on the note. So in theory, the only evidence that could show up as to the party's intent would be Mr. Campbell's testimony that I met with Mr. Meyer and he told me it was very important that Abi's signature be on this document. But there is no such evidence.
Mr. Jadecki, you were shaking your head. I don't want us to get too far from the narrow question I asked. Do you disagree with the statement of Mr. Johnson that the author of these various notes was Mr. Myers' attorney, Mr. Campbell?
I don't think that fact is in the record. And I'll tell you, I've spoken with him and none of them know where the notes came from.
You spoken with whom?
I spoke with Mr. Campbell. At first, Mr. Myers didn't even remember Mr. Campbell's involvement. We figured out in discovery that Mr. Campbell was involved. He has looked at those notes and says, that's not my form note. But he doesn't have an independent recollection of how this came about, quite honestly.
Okay, well, I don't want us to stray from what's in the record at this point. Mr. Johnson, why is it that you say Mr. Campbell prepared the document, other than what we're looking at the screen here where Mr. Myers has said under oath, Mike Campbell prepared the document? I guess that's about as good as it gets.
That's correct.
Okay.
That's his testimony.
Okay. So that's your basis for saying it. You, Mr. Johnson, don't have some other affidavit from Mr. Campbell saying, I prepared these things. You are relying on Mr. Myers' sworn statement that, or testimony under oath, that Mike Campbell, that would be the attorney for Mr. Myers at the time these notes were entered into, that he prepared. That's what this document is. You would have been showing Mr. Myers at that time one of the notes.
Yes, Your Honor. And I believe, and I can double check this in a couple minutes if we need to, I believe in the deposition transcript, there is an exhibit from Mr. Campbell with notes attached to it. I didn't put it in my summary judgment papers because I thought Mr. Myers' testimony was good enough. But I think there is a
it's good enough for where we are now. I
Sure.
see it. I'm ready to move back to you, Mr. Johnson.
So that's my point. He is not a maker. And then you have to look at, well, what did the parties intend? And Mr. Myers apparently doesn't remember anything about how these came into being and is now questioning whether Mr. Campbell actually prepared them. Mr. Golhar testified in his affidavit he didn't prepare them. He also testified that they never had conversations. Mr. Meyer has testified that the only conversation they had were about the specific deal points and not about Mr. Golhar's involvement in the note or as a signer, endorser, maker, guarantor, accommodation party. And so in the absence of any sort of intent as to what Mr. Golhar was signing this for, there's a question as to whether he was signing as an accommodation party under which he would have liability in the note, or his signature is superfluous. And if that's the case, if they never talked about it and someone put a signature block for him to sign and he signed it believing that he was signing somehow in his corporate capacity, which is what his testimony is, a jury could find that because they never spoke about it and because there's no evidence that Mr. Meyer ever believed Mr. Golhar would be liable on the note or ever intended to have Mr. Golhar pay if Summit and Crown couldn't, a jury could find under those facts that Mr. Golhar is not liable on the note. And that's the reason why the accommodation party statute and the comments to that and the case law say that whether one is an accommodation party is a question of fact for a jury. And the question is, what did the parties intend? And so I think given the evidence, there is a tribal issue of that intent, and we would ask that summary judgment be denied as to Mr. Golhar.
Okay. Thank you. Mr. Jodecki, as the movant, I'll let you have the last word. And I'm sure you have things you want to say in response to what you heard from Mr. Johnson. Before you jump into that, talk to me, please, about Higgins's liability. It would seem to be premised on the same arguments you're making as to Golhar. Poor Mr. Higgins has no one here arguing on his behalf. He has stood mute in this litigation so far. Do you believe that the complaint sufficiently alleges a hook for personal liability for him, or awkwardly would it be, if I find Mr. Johnson's argument to be correct, the same situation for Mr. Higgins? Your client says, I didn't think Higgins would be personal. I didn't really think about it. You know, there's this Summit and Crown. They seem legit. I got snookered by them, and they all signed it. But whoever wrote these documents, and the only evidence I have is that that was Attorney Campbell. He put in a bunch of signature lines, and Higgins signed it twice. And so that you, Mr. Jodecki, on behalf of Mr. Myers and ACM3, would still have some burden to convince the ultimate fact finder that Higgins intended to serve as an accommodating party or a maker, and that it wasn't just superfluous. There's a long way of saying, why is it not a question of fact, if it is, for Higgins as well, even though he's taking the path of least resistance here? You're on mute.
Sorry about that. Let me answer that question first, and then I'll move on to Mr. Johnson's argument. A couple of things. Obviously, we didn't, but we could always go back and file a motion for default judgment against Higgins. I do believe the note does, the complaint does provide an allegation that Mr. Higgins signed in his personal capacity. I don't have it in front of me, but I can pull that out.
Okay.
And give you some additional The other thing I'd point out is there's no evidence in the record, unlike what you have here in an argument for Mr. Golhar's intent, that Mr. Higgins did anything other than intend to sign in his personal capacity. I will tell you, the whole intent argument, in my opinion, is a red herring. You never should get to intent based on the clear wording of the note. The cases in Georgia don't do that. We don't do that. And I want to make sure, I want to clear up one other thing. We keep referring to accommodation parties or makers. We say, you can't be one or the other. And the definitive statute on that, I think it's cited in Mr. Johnson's brief as well. But if you go to 11.3.419, which is a statute entitled Instruments for Accommodation, whether you're accommodating party or not, here's what it says. 11.3.419B, an accommodation party may sign the instrument as a maker, drawer, acceptor, or endorser. So you can be an accommodation party that then signs as a maker. And that's what happened in the Darien versus Miller case. You're not one or the other. You look to see how they signed it, and he signed it as a maker. He may be an accommodation party also, but he signed it as a maker. That makes him primarily liable to the lender. Again, he may have other defenses with or claims against his co-makers. 11.3.419B talks about how you sign it. D then limits what your liability can be, but it only limits it in certain circumstances. And that's if a signature of a party to an instrument is accompanied by words indicating unambiguously that the party is guaranteeing collection rather than payment. 11.3.419 goes through what happens if you're a maker who is also an accommodation party. And if you look at note 4, subsection B states an accommodation party is liable on the instrument in the capacity in which the party signed the instrument. And he signed it here as a maker. In most cases, that capacity, this is the note, in most cases, that capacity will be either that of a maker or an endorser of a note. Subsection D, but subsection D provides a limitation on subsection B. If the signature of the accommodation party is accompanied by words indicating unambiguously that the party is guaranteeing collection rather than payment of the instrument, liability is limited to that stated in subsection D. So you could have a situation where you're an accommodation party that might have some limited liability, but you had to indicate that. He signed as a maker. He may be an accommodation party. It's our position that he's a maker, and whether he's a accommodation party or not, he's still a maker. This accommodation party argument, it doesn't matter under the law. It might matter later on if you've got a situation where he wants to sue somebody else, one of his co-makers. There may be some argument there, but with respect to the lender, which is us, he's still a maker and he's still primarily liable. So I don't want to confuse those two terms. It's not an or situation. You can be both.
So I'm clear because you say it's clear. I don't want to miss it. You believe it's clear that Mr. Golhar signed as a maker because of effectively the physical location of his signature. It's below maker, and it is, it sounds very technical, but it is left justified just as far as Summit and Crown Partners is. And so arguably they are co-equal signatures. Summit and Crown that have the two sub-signatures that are indented, and then you've got Higgins and Golhar individually, even though they're not listed as maker up at the top.
Yes, and I think you're right on that, Judge, as far as where the signatures are and whatnot. You don't have a situation where if they were signing on behalf of Summit and Crown, you would expect to see the by line, there's a by and a signature under the first two and not under the second two. The other thing I would point out is when you look at the security deeds, we've got these security deeds in the case. They are only signed once by Summit and Crown. The first two signatures on the note match the first two signatures on the security deed. And that would make sense because Golhar and Higgins don't individually own the collateral. So you can see there's a definite difference in the way the signatures were done.
Okay.
I don't think you ever have to get into intent. And that's why we didn't include an affidavit from our attorney who kind of remembers what happened but doesn't. So, you know, if you get into intent, it becomes a fact issue. I don't disagree with that, but I don't think you ever get into intent here based on the case law. You get 2 signatures, and that carries the day. And in our case, you have, they say individually underneath them, which the other ones don't even say that.
Okay. All right. Blue Summit, what's your understanding, Mr. Jadecki? You didn't say at the outset this morning that at this point you through this partial motion for summary judgment, you're not seeking recovery against Blue Summit. It is a member of S&C, and so is your theory just, look, S&C is liable, I don't need to worry about Blue Summit? Is that why we're not talking about Blue Summit?
Essentially, Your Honor, Walt Higgins and Blue Summit LLC are the members of S&C. And near as we can tell through discovery of the case, Blue Summit is a defunct entity that may have originally been, it was a Wisconsin or a Wyoming entity that doesn't exist anymore. And the sole purpose was to hold Mr. Golhar's interest in Summit and Crown. So practically speaking, I don't think there's a separate liability under the notes for a member. And that's why we did not include him here.
And so thus Higgins's liability is not as a member of Summit and Crown, it's at the same level of liability that Mr. Golhar is. It's as a co-maker or maybe an accommodation party who might also be a maker. But you are putting Higgins and Golhar, the argument for their liability is structurally the same. I get it that you may not have to show much against Higgins because he by default may have effectively admitted liability.
Yeah, that's right, Your Honor. I mean, for purposes of this summary judgment motion, their liability is based on similar argument.
Okay. All right. Mr. Johnson, anything you're itching to add, or you feel like you've been able to set forth your position both in your brief and what we talked about this morning?
I would just add one final thing. Mr. Jadecki keeps saying that my guy signed as a maker. Obviously, the note does not identify him as a maker. To the extent you want to say there's a contradiction between the signature block, which depending on how you look at the configuration, perhaps could be read to make Mr. Golhar a maker, versus the clear and unambiguous definition of maker at the very first part of the note, that itself is seemingly a triable issue as to whether he's a maker. I agree with the proposition that you can both be a maker and an accommodation party. But that situation is not what we have here. Here, the question is whether Mr. Golhar is an accommodation party. That's a question of fact. You've heard my argument.
Okay, I have. I've heard both arguments. Not a question of fact. Yes, a question of fact. And they were well pled. I appreciate this. This has helped me sort through some of this. I blessedly don't deal a lot with Title 11. Title 16, I'm all right with Title 16. Title 11, not as much. So this is helpful. I'm learning new things. And now I can go home and sound really smart by referring to my kids as accommodation parties. I don't think we need to hear from Mr. Barton, and the other lawyers dropped off. They might not have been as interested as I in your arguments. But I think we're good to go. You all will take care of Ms. Foster?
Yes, Your Honor.
Yes, Your Honor.
Great. Okay. Well, I will take this under advisement. Where are we scheduling wise? And I'll ask you, Mr. Jadecki, I think you helped submit the amended scheduling order. Is discovery pretty much closed now, or what's next other than ruling on this?
Well, okay, you check to see if I was muted. I think, Mr. Barton's clients haven't been in the case that long, so there still is discovery ongoing. I think technically under the order, we've got until the end of the month. But I know there's some additional discovery. From my standpoint, we're looking to establish the notes, and then ultimately we'd be looking to establish that we have 2 forged security deeds, and then get those reinstated and potentially go on to a foreclosure sales at some point. We've also got our fraud claims and other claims that are still pending against the Golhar defendants and some others.
Attorney Dortch is still in the mix along with, is that a male or a female?
Paviel Doricks, Your Honor, is a female.
She and her firm are still in. Is that part of the fraud or forgery?
They are still in right now. I will tell you that I have spoken with Ms. Smithers about, we're working something out where they're going to be dismissed very shortly.
Okay.
Obviously, we need court approval, and we'll get everybody's consent to do that. But they're going to be dropped here shortly.
Okay. Mr. Allen, you suddenly appeared.
Yes, Your Honor, I had been listening, was not participating. I only wanted to say, yes, we understand that one of the other defendants has served some discovery for a deposition to take place, I think, at the end of this month. I think they had served the Campbell and Brannon firm. On behalf of the RPL defendants, we anticipate a summary judgment motion that we would file related to the tort claims that have been asserted against our client, the fraud, the RICO, just so Your Honor understands that we anticipate that.
Say that last part one more time.
I only wanted to let Your Honor know that we anticipate filing that as to those claims.
Filing what?
I'm sorry, Your Honor. A motion for summary judgment on behalf of the RPL defendant to dismiss the fraud and the RICO claims.
Okay, got it. And that won't be a late motion? I mean, whatever the new deadlines are, it'll be a timely filed motion?
I believe so, Your Honor.
Okay, great. So we may see another dispositive motion. Mr. Jodecki, I appreciate you have been trying to right-size things as defendants come and go in the case. Because I know originally your motion for summary judgment was more expansive, but we'll work through all those things. Reminder, if you all file something that needs immediate attention, you need to reach out to Ms. Niles. Simply e-filing something checks the box that it's been filed. It doesn't move it to the top of the stack that grows by 100 filings a week for us. So if there's something time sensitive, reach out to Ms. Niles saying, hey, there's this motion to dismiss that we think is pretty easy, or like Mr. Jodecki's been doing well with this. We think these parties can be dropped, and we're bringing this to your attention so it doesn't sit there for 6 months. We're happy to, can't guarantee that it moves to the top of the pile. I can guarantee that it will not if you don't flag it as something that you have a good faith basis to say it's kind of urgent, or if you dealt with this, we'd reduce a case that's this big down to this big. We're always happy to try to do that. Uh-oh, it looks like some people dropped off, not that they meant to, because they're trying to get back in.
And Your Honor, I had sent the link to those attorneys who had indicated they had gotten knocked off, so I think they just got back on.
Okay, so Ms. Tuttle and Ms. Gilroy, we just settled the case on behalf of your clients. It's a very favorable disposition. Mr. Golhar is transferring all his liability to your clients. So, good work.
Yeah, sorry about that, Your Honor. I got booted off real early, but was watching on YouTube. So it's definitely a fun way to have your parents participate.
Yeah, there you go.
I actually agree with Mr. Allen. Resolutions will do the same thing. We'll have our own summary judgment motion at some point. You got it right, Your Honor. Everything is timely and within that new scheduling order. So things are moving well.
Okay.
Yeah, as for me as well, Your Honor, as you know, Mr. Allen and I represent RPL jointly, and we expect also a summary judgment motion jointly with Mr. Allen as to the various claims in this case, and it will be timely filed, Your Honor.
Okay.
And sorry, we got booted off as well, and we were watching via YouTube.
All right. Sorry, I didn't notice there were people in the lobby. Someone mentioned Campbell and Brannon. Is that the Mr. Campbell? Is Campbell and Brannon, or it's a different Campbell? Same?
It's the same.
Yes.
Campbell and Brannon does lots of closings? Okay,
Yes.
so full disclosure, we're selling our house, and I'm pretty sure Campbell and Brannon is doing our closing at the end of August. I don't think that's an issue. I don't know Mr. Campbell, and I promise if I see him, I won't ask him, hey, why did you put Mr. Golhar's signature line in there? But I didn't pick that firm. The real estate people did, and I have to spend too much of my time one day at a closing at the end of the month. So, and then I get to move into my in-laws basement. The glamorous life of a judge. So we'll see how that goes. But I appreciate everyone's time on this Friday. Everyone have a safe and healthy weekend. Ms. Niles will reach out if we have any follow-up questions based on what you've shared with us. But otherwise, we'll take this under advisement. It could come to pass that you get an email from Ms. Niles saying that judge has thought about it and believes that the answer is X, and puts the pen into the hand of Mr. Jodecki or Mr. Johnson to come up with a proposed order. I don't know how this one will play out, but don't be shocked if that happens. Don't despair if it's not happening. It just means we'll be writing it instead. Mr. Jodecki, anything else on behalf of Mr. Myers and his corporate entity?
No, Your Honor.
All right, Mr. Johnson, anything else on behalf of Mr. Golhar?
No, Your Honor, we appreciate your time.
All right, thank you everyone for dialing in. I'll see you soon.
Good
Thank you.
luck with
Thank
the
you, Your
move.
Honor.
Hey, thanks.
Bye-bye.
Bye.